Hi there. In this video, I'm going to be looking at human resource management strategies, but specifically focusing on workplace disputes. So, what are disputes? Well, an industrial dispute is a disagreement over an issue or group of issues between an employer and its employees, which results essentially in employees ceasing work. So a strike refers to situations in which workers withdraw their labour. These are the most overt form of industrial action and aim to attract publicity and support for the employee's case. And then we've also got lockouts. These occur when employers close the entrance to a workplace and refuse admission to the workers. Lockouts have been used frequently in long disputes in manufacturing to promote concession bargaining, to push employees to sign individual agreements, and as a direct response to strike action. Some of the major causes of disputes include remuneration, so pay and conditions, employment conditions, job security issues as well. Some other causes may also include health and safety, managerial policy, union issues as well. And again, this list is not exhaustive at all. This is just a snapshot. So these things cause disputes. But then how do they try and resolve them? Okay, so first thing is negotiation. Now, negotiation is a method of resolving disputes when discussions between the parties result in a compromise and a formal or informal agreement. This process can benefit the parties involved by increasing their knowledge of company policy, businesses' objectives, workers' concerns, and issues involved in implementing change. We've also got mediation. Mediation is the confidential discussion of issues in a non-threatening environment in the presence of a neutral, objective third party. The third party may be independent and agreed on by key parties in a dispute, or a representative from a business, tribunal, or a government agency such as Fair Work Australia, the Australian Human Rights Commission, or the Anti-Discrimination Board. Mediation as an alternative dispute resolution technique is increasingly popular in Australia. It allows the parties to become empowered by resolving their own disputes, and it reduces the risk of disputes escalating and leading to expensive legal costs or industrial action. And we also have grievance procedures. Now, these are formal procedures generally written into an award or agreement that state the agreed processes in order to resolve the disputes in the workplace. These are useful in reducing the risk of an issue rapidly becoming a serious dispute. Most businesses have established a formal process, now required in modern awards and other agreements, by which issues can be handled. So it's basically a step-by-step process on how to deal with any disputes. We can also have the involvement of courts and tribunals. Industrial disputes that escalate to the level of courts and tribunals are most likely to occur when disputes have passed their nominal expiry date. Bargaining has commenced towards a new agreement and negotiations have failed. Employees and employers then enter a period where industrial action may be protected until a new agreement is developed. We can look at here conciliation and arbitration. Conciliation is a process where a third party is involved in helping two other parties reach an agreement. The conciliation member calls a conference and attempts to help both sides reach an argument. The member may require all parties to continue negotiations on some aspects, reduce the ambit of the dispute, or develop other strategies to resolve the dispute and then report back for another conference. If conciliation fails, the matter may be referred to arbitration if it is in the award or agreement, or if the parties agree. So arbitration then is the process where a third party hears both sides of a dispute and makes a legally binding decision to resolve the dispute. In this situation, a member or a panel of members hears both sides of the dispute in a more formal court-like setting. A judgment, for example an order, is handed down based on the merits of the evidence that becomes legally binding on all parties. Orders may end a restrictive work practice or behaviour such as a lockout, or require a secret ballot of union members if strike action is proposed. Fair Work Australia may also order that staff be reinstated or that the parties return to the tribunal at a later date for further negotiations. We've also got common law action. This is open to any party involved in or affected by industrial action. This option is not available if the action is a protected action during a bargaining period. Such action, the common law action, is costly and generally considered a last resort. So what are some benefits and costs of workplace disputes? And I want to preface this by saying that these lists are not exhaustive. There's quite a lot more. So some benefits are it increases the empowerment of all parties, so then who own an agreement. Conflict helps workers to gain management's attention on major issues that may have caused dissatisfaction and stress for a very long time. Governments can change their policies in response to workplace conflict as a result of that attention. Some of the costs, however, lost production and sales. It adversely affects a firm's income and levels of debt, and it may damage the reputation. There might be some community bitterness towards unions, employees, or employers in industries where disputes affect the general public. And working relationships may suffer as a result of conflict or the methods used to resolve the conflict. So I hope this brief video on workplace disputes has been useful. The next video will start looking at the effectiveness of human resource management and focus on the indicators of how effective human resource management has been. Thank you.